Good morning. Committee will come to order. Welcome, everyone. The clerk will call the roll to see if we have a quorum.
Mr. Conyers?
Present.
Mr. Berman? Mr. Boucher? Mr. Nadler? Mr. Scott? Mr. Watt? Ms. Lofgren? Ms. Jackson-Lee? Ms. Wooters? Mr. Delahunt? Mr. Cohen? Mr. Johnson? Mr. Pierre-Louis? Mr. Quigley? Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Baldwin? Mr. Gonzalez? Mr. Weiner? Mr. Schiff? Ms. Sanchez? Present. Mr. Maffei? Mr. Polis? Mr. Smith? Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Lundgren? Mr. Issa? Mr. Forbes? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz present. Mr. Rooney? Mr. Rooney present. Mr. Harper? Mr. Smith? Mr. Smith? Mr. Smith present. Mr. Nadler? We look forward to working with FMCSA to address to make this program truly effective and improve highway safety. Mr. Maffei? Ms. Baldwin? Mr. Chairman, 15 members responded to the quorum call.
So we have a working quorum, and pursuant to notice, I call up H.R. 5503 and ask the clerk to report the bill.
H.R. 5503, a bill to revise laws regarding liability in certain civil actions arising from maritime incidents and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. Members of the committee, we're here today to deal with the April 20th explosion on the Deepwater Horizon oil drilling platform that resulted in the death of 11 men and injury to more than 17 others, in addition to leading to the most massive environmental disaster in the history of the nation. There was poisoning, widespread swaths of the Gulf of Mexico, killing wildlife, ruining wetlands, wreaking economic havoc in the Gulf of Mexico. The disaster not only highlighted gaps in our ability to engage and regulate deepwater drilling, but also major legal loopholes in the applicable statutes. And so we focus today on those legal liability issues within the committee's jurisdiction. We found that the current state of the law regarding these liability issues is outdated, is unfair, and operates against our nation's interests. The three key laws in effect all date from the mid-1800s. The Death on the High Seas Act, the Jones Act, and the Limitation on Liability Act. So the bill before us responds to these unfair laws and offers justice to current and future victims of oil and shipping accidents. It amends the Death on the High Seas Act and Jones Act to permit non-pecuniary damages. It repeals the Limitation on Liability Act. It makes a very narrow change to the Class Action Fairness Act to allow attorneys general to bring remedial actions in their own state courts. It limits the ability of parties responsible for oil and similar spills to prevent their employees from speaking to the media. It prevents parties responsible for oil spills from using bankruptcy courts as a subterfuge to leave victims without adequate legal recourse. And it provides that these changes will apply to pending and future cases, consistent with previous liability law changes enacted by Congress. I now would like to recognize my friend Lamar Smith, the ranking member, for his opening comments.
Thank you, Mr. Chairman. Mr. Chairman, although I believe this legislation is well intended, I have concerns about H.R. 5503 in its current form. It is important that BP and other responsible parties pay all costs associated with the oil spill and that they be held fully accountable. However, H.R. 5503 is overly broad and will have unintended consequences that reach well beyond the Gulf Coast disaster. It is incredible that the sweeping changes this bill makes are being proposed without the benefit of even one legislative hearing on any of the bill's provisions. For example, H.R. 5503 makes several changes to longstanding U.S. maritime liability laws. These changes virtually rewrite U.S. maritime liability law and in some instances make it out of step with the laws of nearly every other maritime nation. The most problematic change is the repeal of the ship owner's liability of Limitation of Liability Act. Maritime accidents usually involve numerous parties with competing claims, loss of life or personal injury, and multiple jurisdictions in which claims may be filed. The Limitation of Liability Act addresses these problems by allowing for consolidation of all claims arising out of a maritime accident in one federal form. It also creates a fund to pay personal injury and death claims over and above the Act's general liability limit. Despite the Act's importance, Section 4 of this bill repeals the Act without adopting any replacement legislation to fill the void. Repeal of the Act introduces uncertainty and in many cases may result in inadequate compensation to personal injury and wrongful death claimants. Repeal of the Act also eliminates from U.S. law the globally recognized principle that vessel owner liability should be limited. This principle is so widely accepted that it has been adopted in an international convention that 52 of some of the world's largest maritime nations have signed. Other sections of this law are also questionable. Section 3 allows for recovery of non-economic damages and wrongful death actions under the Jones Act. While this may seem like a fair result, it actually creates inequities because the Jones Act is an analog to land-based workers' compensation statutes which do not apply at sea. Workers' compensation generally does not allow for the recovery of non-economic damages. Without having held a legislative hearing to understand the full impact of this change on injured workers, employers, shippers, and consumers, we should not rush this provision through today. These extensive changes to U.S. maritime liability law, which apply well beyond oil spills, threaten to increase dramatically the cost of shipping goods, an increase that will be borne by all American consumers. Additionally, the legislation unnecessarily amends the Class Action Fairness Act. The effect of this will be to open up the possibility of enterprising trial lawyers gaming the system and circumventing federal law to keep class actions out of federal court. Finally, by giving Oil Pollution Act claimants veto power over bankruptcy asset sales of companies with OPA liability, Section 7 of the bill effectively gives these claimants control of the bankruptcy process. However, giving OPA claimants this veto power seriously curtails the rights of other bankruptcy claimants, including the secured creditors, pension funds, other tort victims, and state and local governments. Because this bill applies retroactively, there is no reason to push this bill through committee today without having conducted a single legislative hearing on its sweeping changes. A hearing would have addressed the questionable parts of the legislation. As we amend the law to ensure that BP is held accountable, we should avoid harming the national interest at the same time. Thank you, Mr. Chairman. Yield back.
Does any member of the committee have a brief opening comment that they would like us to know about?
Nice, gentle way. Let's go quick.
Mr. Chairman.
Ms. Sheila Jackson-Lee.
Mr. Chairman, I want to thank you for your leadership on this very crucial and important issue that is a quick response to the horrific tragedy of 11 lives lost in the Gulf on the Deepwater Horizon, and the families that we both had an opportunity to visit with and talk with on the enormous impact that some of the laws that you're presently correcting are having on their ability to, in essence, not recover their lost one, but to be able to provide for their remaining family members. I've been to the Gulf twice and expect to go back. I live in the Gulf region and know that the pain is very, very difficult. The fear of bankruptcy of BP, the fear of the claim system not working, all of these issues are discussed in the underlying bill. I am delighted that some of the aspects of our concerns have been addressed in the manager's amendment, and I look forward to addressing concerns that impact our area that may be unique. The cruise industry, the issues concerning small independent energy companies, all of that has to be of concern as we look at this particular incident so that it does not happen again, and we create a legal framework to address the questions that have been raised by the tragedy of BP. In our meeting yesterday with U.S. Coast Guard, they indicated that they are able to capture about 23,000 barrels a day, but as has been reported, it may be upwards of 100,000 barrels a day. This is going to be, that is spilling off into the Gulf. This is going to be a long haul. And I believe the balance of working together with our respective committees, working with the Judiciary Committee, understanding the economic needs of the Gulf, understanding the loss of these very dear souls and the difficulty of their families will be the best route for all of us to move forward to address this in the right kind of legislative manner. I thank you, Mr. Chairman. I thank you for the discussion we will have on some of the amendments or thoughts that I have going forward. I yield back.
Mr. Poe would like to speak. Mr. Poe of Texas.
Judge Poe of Texas.
Thank you, Mr. Chairman. H.R. 5503 has been rushed through the committee process following the explosion of the Deepwater Horizon. Since this horrible accident, the committee has held one general oversight hearing on liability related to the Gulf oil spill, and most of these issues included in H.R. 5503 were not even discussed. The unintended consequences of this legislation could be widespread. Among other things, H.R. 5503 repeals Limitation on Liability Act, which is the fundamental change and a fundamental change in U.S. maritime law. This change would end the longstanding practice in the U.S. that all maritime claims be determined in one federal forum. It also ends the limitation on U.S. vessels owners' liability, a limitation which in its place is virtually done in every other country in their maritime industry. The loss of this limitation will handicap U.S. mariners. H.R. 5503 would cause insurance rates to spin out of control, damaging American maritime industry, putting thousands of jobs in jeopardy. In other words, the insurance rates will be so high, these companies cannot afford insurance, they won't have insurance, and they will be out of business. That is the consequence and maybe unintended consequence of this legislation. Just as the offshore drilling moratorium was hastily enacted by the administration, a ruling by a federal judge declared that to be illegal yesterday, this bill is being rushed through the committee process. The committee needs to act prudently and analyze important issues and not rush a bill to the floor which could have widespread unintended consequences and make another disaster in the Gulf of Mexico. I yield back.
Mike Quigley, Illinois.
Thank you, Mr. Chairman. The opposition to this bill, and I'm assuming the rest of the bills that are up today, assumes that the Deepwater Horizon was an isolated incident that could never happen again. Anyone who imagines that all of the rigs that are out there are safe and that this could never happen again aren't dealing with reality, and that spills have taken place before in Alaska and other places. They take place on virtually a daily basis, and that the serious problem with this legislation is the fact that, unfortunately, it is reactive, and that it should have taken place some time ago to address these possibilities. We were living on borrowed time before. To imagine that something like this won't happen again is fanciful, and I welcome what we do here today and hope that we can remedy the problems in the future.
The chair notes that that Mrs. Courtney Kemp, wife of Wyatt Kemp, is in the committee room, sitting in the front row. Mrs. Shelley Anderson, wife of Jason Anderson, is here with us today, as is Attorney Keith Jones, the father of Gordon Jones. We welcome all of you back to the committee hearing. And the chair recognizes Mel Watt, North Carolina.
Mr. Chairman, I have an amendment at the desk.
Wait a minute. You're in it. I thought you wanted to get your 2 cents worth in before we started.
I just want to get started.
Well, there may be someone else with 2 cents, and But seeing, oh, wait a minute, there is one. Mr. Maffei.
Mr. Chairman, thank you. I have 2 cents and just 2 cents, but I do support this bill. I am concerned about some unintended consequences, but that's why we're here. That's why we have an amendment process, and if an amendment needs to be offered. But it does seem to me there are some intended consequences of this legislation, and that is to make sure that the costs of offshore drilling actually reflect the costs and risks of offshore drilling. I think that's an extraordinarily important thing. And of course, the urgency of this is not something that we decided. It's something that happened because of this emergency in the Gulf. And so I'd actually ask unanimous consent that I become a co-sponsor of H.R. 5503.
Without objection.
Thank you, Mr. Chairman.
The chair has a manager's amendment at the desk that I'd like to report before we recognize Mel Watt for his amendment. Clerk will report.
Amendment to H.R. 5503 offered by Mr. Conyers of Michigan and Ms. Jackson Lee of Texas. Page 2, line 8, insert "and" after the semicolon. Page 2, strike lines 9 through 11. Page 2, line 12, strike "D" and insert "C." Beginning on page 2, strike line 20.
I ask unanimous consent the amendment be considered as read. And let me explain this. It is an uncomplicated amendment here. First Amendment clarifies that the personal representative of the state can file an action under the Death on the High Seas Act. And the Death on the High Seas Act is also amended so that state law will provide which members of the family of the deceased may bring a case to recover compensation for the loss of their loved one. Secondly, the amendment removes an exception in the Jones Act for oil companies, which has restricted the ability of foreign workers and their families to recover for injury or death in United States courts. That provision currently hurts Americans working in the oil and gas industry, since it provides an incentive for oil companies to hire foreign workers to limit their legal liability. Thirdly, the amendment makes a conforming change so that the definition of a mass action will be amended along with the definition of a class action so that cases brought on behalf of a state can remain in state courts, which have sometimes more expertise with state law. And finally, the amendment makes a number of clarifications to the bankruptcy changes in the bill to better ensure that those responsible for oil spills can't use the bankruptcy code to avoid their responsibility to the victims of the spill. And with that explanation, I turn to Lamar Smith.
Thank you, Mr. Chairman. This manager's amendment makes largely technical corrections to the underlying bill. Unfortunately, in doing so, it avoids the opportunity to refocus this bill directly on oil spill liability in general and on the liability of those responsible for the Gulf Coast oil spill in particular. Additionally, in several places, the manager's amendment makes this bill's consequences for others who not only have nothing to do with this oil spill, but are not even involved in the oil industry more severe. As I mentioned earlier, I believe the intent of this bill is good. It is important that all those responsible for the Gulf oil spill and any future oil spills are held fully accountable. But the underlying bill and the manager's amendment go well beyond this intent. This committee should focus on considering legislation that is needed to ensure that BP and future oil spillers are held responsible for their negligence rather than on legislation that negatively affects the entire U.S. maritime industry and other uninvolved third parties. Regrettably, the manager's amendment makes things worse and actually makes the unintended consequences of the bill more regrettable. So, Mr. Chairman, I have to oppose the manager's amendment and yield back.
All in favor of the manager's amendment signify by saying aye. Aye. All opposed signify by saying no. The ayes have it. And the manager's amendment is agreed to. And we now turn to Mel Watt. We turn to Mr. Smith.
Mr. Chairman, I have an amendment at the desk. I said I had an amendment at the desk.
Oh, the clerk will report the amendment.
Amendment to H.R. 5503 offered by Mr. Smith. Add at the end the following. Section limitation on application of Act to claims arising out of oil spills. This Act and the amendments made by this Act shall not apply to any claim other than a claim arising out of an oil spill.
Mr. Smith?
Mr. Chairman, this amendment is very simple, straightforward, and easy to support. It is of great importance if the true intent of this bill is to hold those responsible for the Gulf oil spill and future oil spills fully accountable. The amendment adds to the end of the bill a very short section that simply states, quote, "This Act and the amendments made by this Act shall not apply to any claim other than a claim arising out of an oil spill," end quote. If the bill is intended to address the Gulf oil spill, then the committee should accept this amendment to make its purpose clear. If, on the other hand, this bill is intended to make major changes in U.S. maritime and class action law apart from this oil spill, there is no reason to rush this bill through committee today without holding even one legislative hearing on the bill's provisions. All of us want to hold BP fully accountable for all the damage it has done in the Gulf and surrounding coastal areas. Neither BP nor any company that in the future creates an oil pollution disaster should be let off the hook. This amendment ensures that BP and those responsible for future oil spills are held fully accountable, while at the same time restricting the unintended consequences of this bill. I hope we'll adopt this amendment. Mr. Chairman, I'll yield back.
It sounds reasonable, yes, but there's a problem here, Brother Smith. And here's what it is. What this amendment does is narrow the bill to only cases of oil spills. And I think that's the wrong approach. We're taking a wider view in our major bill. And our examination into the Gulf oil spill disaster has exposed deficiencies in maritime liability law. And that is what we are trying to correct here today. This isn't just about BP's oil spill. That's just the tip of the iceberg. We don't know how many more are waiting to happen. But there's a problem with the law, as I've indicated in my opening statement. It's important that we realize this. We've got 3 laws here that are so out of date. Well, they're ancient. What we want to do here today, and you can hold as many hearings as you want to get to the bottom of this, but we want to permit non-pecuniary damages on the High Seas Act and the Jones Act that are not allowed now. I don't know how many discussions and witnesses we want to bring forward on that. We want to repeal the Limitation on Liability Act. That goes beyond the spill. We want to make a change in the Class Action Fairness Act to allow attorney generals in the states to bring their own remedial actions in state courts. So it's not just a matter of looking with a very narrow blinder on what happened here on April the 20th. It goes beyond that, and that's why, notwithstanding the good intentions of this amendment, it's way too small for the scope of the problem before me, and I'm unable to support you in this request. All in favor of the Smith Amendment indicate by saying aye. Aye. All opposed to the Smith Amendment indicate by saying no. Recorded vote is requested. Clerk will call the roll.
Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Berman? Mr. Boucher? Mr. Nadler? Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Ms. Waters? Mr. Delahunt? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Pierre-Louisi? Mr. Pierre-Louisi votes no. Mr. Quigley? Mr. Quigley votes no. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Ms. Baldwin? Ms. Baldwin votes no. Mr. Gonzalez? Mr. Gonzalez votes no. Mr. Weiner? Mr. Schiff? Mr. Schiff votes no. Ms. Sanchez? Ms. Sanchez votes no. Mr. Maffei? Mr. Maffei votes no. Mr. Polis? Mr. Smith? Mr. Smith votes aye. Mr. Goodlatte? Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Coble? Mr. Coble votes aye. Mr. Gallagly? Mr. Gallagly votes aye. Mr. Lundgren? Mr. Issa? Mr. Forbes? Mr. Forbes votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes aye. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Rooney? Mr. Rooney votes yes. Mr. Harper? Mr. Harper votes aye.
Mr. Weiner.
Mr. Weiner is not recorded. Mr. Weiner passes.
Mr. Nadler.
Mr. Nadler votes no.
Mr. Berman, Chairman Berman.
Mr. Berman votes no.
Mr. Weiner.
Mr. Weiner votes no.
Clerk. Oh, Darrell Issa.
Mr. Issa is not recorded. Mr. Issa votes yes.
Clerk will report.
Mr. Chairman, 14 members voted aye and 19 members voted nay.
Amendment's unsuccessful. Chair recognizes the gentleman from North Carolina, Mel Watt.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 5503, offered by Mr. Watt of North Carolina. Page
Ask unanimous consent the amendment be considered as read.
Gentleman's recognized.
Thank you, Mr. Chairman. Mr. Chairman, I can't imagine that there's anybody in this audience in the United States, possibly in the world, who doesn't feel absolute disdain for the situation that we are in at this moment with the oil spill, and probably have personalized that to be absolute disdain for BP because they're the intermediary that is responsible for the oil spill. And while I have some reluctance to offer this amendment, because some people may say that it represents an attempt to protect BP or show some respect for BP, I want to emphasize that that is not the case. What I am showing respect for is, I believe, the rule of law and the sanctity of contracts that exist. So this amendment, the effect of the amendment would be to strike the retroactive application of this law to pending cases and to make it apply only prospectively. I support, and the reason I voted against Mr. Smith's amendment, I support all of the positive aspects of the bill. As we go forward, we need to restructure this whole thing and put a whole new set of rules around it. But I think we, in the Judiciary Committee in particular, must not lose sight of our constitutional and rule of law considerations. And I think that making this law retroactive, have retroactive application, would violate both of those principles. There's no need for me to elaborate on that statement any further. I think it's a simple amendment, and members of the committee obviously will go wherever they feel like they have to go on the amendment. But I don't think we in the Judiciary Committee should be making laws that have retroactive effect or abrogate existing contracts, and that's the position I've taken in a number of different cases. And despite my disdain for where we are and for BP, I think there are some considerations that are more important in the bigger picture, and one of those is the constitutionality, and one of those is the rule of law. I yield back, Mr. Chairman.
Well, this is an interesting situation. We've been voting retroactive laws since before you came to Congress, Brother Watt, and we aren't going to stop now because of some interpretation you brought forward, since you voted for retroactivity yourself. And I hope you ask me what cases so I can call them off. Who else seeks
If the gentleman is yielding to me,
sure, I'll yield.
I'll ask that question. I think you were going to answer it anyway.
No, I wasn't going to answer.
Okay, well, you can. I'll ask the question. That'll give you the entree to answer it.
Yeah. What about the 9/11 bill?
9/11 bill set up a new fund that was going forward.
It wasn't retroactive?
Had no retroactive application.
Okay, what about Lily Ledbetter?
Had no retroactive application to Ms. Ledbetter.
That was not retroactive? What about the 9/11
Did she go back
bill?
and win her lawsuit?
It applied to other pending cases. Anybody? Okay. Lamar Smith.
Thank you, Mr. Chairman. Mr. Chairman, I'm actually going to be easier on Mr. Watt because I do appreciate his wanting to respect the sanctity of contracts, as he put it, and the rule of law. But I would point out to the gentleman from North Carolina that if he's worried about a new set of rules, as I think he has a right to be, he ought to be concerned about the underlying bill because of the new set of rules it provides for the maritime industry, which is perhaps far greater. So that's another reason to take a look at the underlying bill. The effect of this amendment, Mr. Chairman, as I understand it, is to prevent current BP claims from being covered under this bill. And so I have more concern about those claims being able to be addressed than I do about the retroactivity, so I'll oppose this amendment.
Mr. Chairman of the Constitution Committee, Jerry Nadler.
Thank you, Mr. Chairman. I oppose the amendment. First of all, but I think we ought to clarify it. We're not talking about retroactive legislation here. We're talking about legislation for pending cases. Now, Lilly Ledbetter was not retroactive, but it did affect pending cases. Lilly Ledbetter herself, her case was over by the time we passed the bill, so it didn't affect her, but it affected all pending cases on the date the bill was passed. We often apply laws to pending litigation. The Lilly Ledbetter Fair Pay Act, Protection of Lawful Commerce in Arms Act, the Superfund laws of 1980 on cleaning up hazardous waste applied to pending cases and was specifically found constitutional by the Supreme Court in the case of Eastern Enterprises versus Apfel in 1998. There are a number of other Supreme Court cases that I can cite, but won't bother. This is certainly not nearly unprecedented. We often apply laws to pending cases. Second of all, I don't see any issue of abrogation of contract here. We're not abrogating a contract, we're changing a law. There was no contract that said their liability was limited. But first of all, under the Constitution, the federal government, unlike the states, can abrogate contracts. The states cannot. The federal government can. But we're not even talking about that here. We're talking about changing the law. Now, if they relied on the law, we're changing it. We do that often enough. I think in terms of the equities to the American taxpayer and to all the people in the Gulf, we ought to make this affect all pending cases. And I therefore, and I see no constitutional or equitable problem with it, and I therefore urge defeat of the amendment.
Steve King.
Thank you, Mr. Chairman. I rise in defense of the gentleman from North Carolina, whom I think is very deserving of it. I just thumbed through this Constitution, Article 1, Section 9, and it says, no bill of attainder or ex post facto law shall be passed. I think when I read this language here of Mr. Watt's amendment, it says exactly that to me, that no this will not be an ex post facto law, that it doesn't apply to cases pending or after such date of the enactment of this piece of legislation. I think that would be a normal clarification that's implicit in what we do, but in this case we're explicitly addressing a subject matter that would turn it into an ex post facto law should we not have Mr. Watt's amendment. And I just want to make that point into the record and yield back.
Would the gentleman yield?
Time.
Would the gentleman yield?
He yielded back. Mike Quigley, Illinois.
I think the argument for this amendment understands what attainder-like punishments we're talking about in the Constitution. This bill does not impose attainder-like criminal punishments on BP. And the case law, as Mr. Nadler started to point out, is pretty clear that you can have retroactive laws, but they must have a rational legislative purpose. I can't imagine that someone wouldn't understand that the largest oil disaster in American history would not qualify. In fact, this is second or third now in the history of this world as an environmental disaster. So to assume that it doesn't qualify negates the reality of how dramatic a disaster this is, and that it obviously has a rational legislative purpose. So obviously, discuss the Superfund laws. The standard was established in pension benefit versus R.A. Gray. It simply says that the retroactive laws must have a rational legislative purpose. So I think those who support this don't understand what the Constitution was talking about in those concerns, and that the Supreme Court has ruled several times that, and there is a standard in here, that this is not unconstitutional.
Dan Lundgren, California.
Thank you very much, Mr. Chairman. I have a couple questions on this for the chairman, whoever can answer it, and that is, if this is not limited just to this incident, as I understand it, this would affect all pending cases that exist for Death on the High Seas Act or Jones Act in any incident. Is that true? I mean, for all such incidents that occur or have occurred for which there is a pending action, Mr. Chairman?
Yes, I think it is.
Do we know how many actions there are out there?
Nobody knows.
Can someone tell me, has this been the state of the law since both of these statutes were passed? That is, not allowing for this kind of recovery, non-economic damages?
Yes, that's why we're bringing the bill forward.
No, I understand that, Mr. Chairman. What I want to know is, these are laws that have been on the books since the 1920s, as I understand it. I certainly appreciate the tragedy that we're talking about, but we're talking about a change in law that deals with all actions under both of these acts, as I understand it. And I was just wondering whether if we have any evidence or any hearings about the impact of the laws as they have occurred in the past, that is, as actions have occurred in the past. I mean, does anybody have any information before this committee on that?
Well, we have enough information about the results of the law to know that it's unfair and we want to change it. 11 people were...
No, I understand that, Mr. Chairman, and I appreciate it very much.
Let me ask you about, let me just try to explain it in terms of the airline circumstances. We changed the law with reference to airline injuries and applied it to two pending cases. And you were, I think, with us on that.
Are these strict liability laws that we're dealing with? Are these strict liability statutes that we're dealing with, underlying law?
No, they're negligence-based, not strict liability.
Thank you, Mr. Chairman. I appreciate us bringing this bill to the committee. The only concern I would raise is normally we have an opportunity to have hearings to understand the impact. If this were just limited to the instant that we're referring to, or like incidents, then I could understand the suggestion that we don't need any hearings on it, we don't need to review how this law has impacted the maritime trade, etc. And then it would be easy for me to make a decision. Unfortunately, we have a scant record. We have no record whatsoever in terms of the impact of this change on the statutes that existed since the 1920s. And I think that puts us in a difficult situation, those of us who would like to do the right thing in this particular circumstance, but also would like to know the underlying implications of a significant change in the overall law as we have here. So I thank the chairman.
The gentleman yield.
Well, I'll happy to yield, gentlemen.
And I'm not going to claim my own time. I appreciate your yielding a little time. I, too, share this question of when is it that the majority decided that no crisis should be allowed to go to waste? When is it we decided that we would pass legislation without study and deliberate activity, particularly one that has no sunset and has been on the books since before any of us in this room were born? Why in the world are we doing this today except to take opportunistic advantage of 11 people dying in the Gulf.
Well,
Take opportunistic crisis advantage. And I share with the gentleman that this is inappropriate.
If I could take back my time, what I'm saying is, I'm sorry we aren't crafting legislation to deal with the specific circumstance we have here. I think everybody in America is aware of what happened. Everybody in America would respond in a particular way. However, because of the failure of some of the amendments, we have a situation in which this is not just limited to this situation. This applies to all such incidents on the high seas dealing with general maritime commerce. And frankly, I would hope that we would have a better basis for making such decisions than that. And I appreciate the expedition with which we are dealing with the specifics of the tragedy that took place in the Gulf. But I would just say, once again, it usually is good for us to have at least some record and some evidence and some opportunity to question how the law has worked than just bringing the bill up like this. And I appreciate it, Mr. Chairman, and I would yield back the balance.
Well, could I merely pacify my friends here? On May 27th, we had a full committee hearing on every single issue on every one of the three bills that we seek to amend here today. And both of you, I remember distinctly, were here for that hearing. And I'm getting the transcript for you right now, in which this isn't coming out of the sky somewhere. It was that hearing that led us to make these corrections that are before you now. So I know we have very busy schedules, and you can't remember everything that happens at every hearing. But we have gone into this. This did not come out of the sky or out of thin air. And I will have the hearings for your scrutiny coming now. Mr. Berman.
Thank you, Mr. Chairman. I appreciate the gentleman's amendment. I do think it's important to spend at least a little time contemplating whether in the desire to address a crisis, are we doing things which are not consistent with traditional notions of rule of law. But I do think in this situation where we're dealing with civil law, it's pretty well established that the Congress, particularly if it manifests the intent to do so, can change the liability aspects and the procedural aspects for dealing with incidents which have already occurred and apply it retroactively. I was very involved in the major amendments in 1986 to the False Claims Act and in amendments to those amendments since that time. And we always manifested the intention that the changes made in that language would apply to fraudulent acts previously committed. We raised liabilities. We raised liability provisions. We changed procedural rules. We made a number of changes in the False Claims Act with the intent that it apply to retroactively to not just simply to cases pending, but to incidents that occurred prior to the effective date of the law. And in the context of the contract sanctity argument, I'm not exactly sure what the gentleman's referring to, but we do not interpret the constitutional provisions regarding contracts as contract sanctity. We pass a minimum wage law and a overtime pay law, and the public policy behind that law trumps an employer's contract with his worker every day. We do this in a number of situations where we determine as a matter of public policy based on the constitutional basis under the Commerce Clause and other provisions for enacting legislation that we are going to trump contracts that are now in effect. So I don't view the contractual provisions in the Constitution as creating a contract sanctity, and I don't think the courts have recognized that for 50 years, 70 years actually.
Would the gentleman yield for a question?
Sure.
Have we ever retroactively increased minimum wage?
We have increased the minimum wage and made it apply and trump contracts that required an employer to pay less than that wage. There's no question about it.
But not for work already done or contracts already delivered.
But for contracts already made.
But not delivered.
Well, my comment on the minimum wage law dealt with the issue of contract sanctity. As you probably know from your own business experience, sometimes those contracts aren't so sanctified.
Arizona, Mr. Franks.
Thank you, Mr. Chairman. Mr. Chairman, I guess there's a little confusion here from my perspective. If Mr. Watt's, may I ask if Mr. Watt would yield for a question?
Sure time.
Yeah, Mr. Watt, you know, when I find myself seemingly to agree with you, I don't know whether to declare I want to buy the whole committee dinner or try to understand this a little bit better. If I understand your amendment, it says it shall apply to cases pending on or after such a date. The pending
I'm
part.
striking that language.
Yes, but the pending
not
part
apply.
concerns me because if we take out the entire, if we take out the word pending, it occurs to me that we could be taking out a date and that this could apply completely retroactively. Is that potentially possible?
I don't believe so because I don't think
You don't think it would be interpreted that way?
I don't think a fair interpretation. That might be why the gentleman is having trouble being in the same position that I am.
I think maybe
I look at these things from a fairness perspective.
Perhaps that you thought I was agreeing with you, but I was just confused. Well,
Mr. King has been in that position a couple of times the last couple of weeks too, so he's feeling equally.
Well, I guess my last thought then is are you trying to make this forward legislation, or by using the word pending, would that encompass cases that are already pending and exacerbate the concerns on the part of some of us related to retroactive legislation?
If the gentleman would yield, that's not my intent. My intent is to have this apply fully to going forward, the new law apply fully going forward. I support the purposes of the bill. I just don't think it's fair to apply it retroactively. And I said that in my opening statement.
Yeah. Yes, you did.
No.
Thank you, Mr. Chairman.
Subcommittee Chair Bobby Scott, Virginia.
Thank you, Mr. Chairman. Mr. Chairman, first of all, I don't think the retroactive application is needed for BP. They're looking at criminal violations. They have strict liability civil penalties per barrel that appear to be running up into the billions. They've already put $20 billion on the table, and there's every indication that there's going to be more where that came from. So the victims should be fully compensated without the retroactivity. Unfortunately, we've done this retroactivity before, as it's been pointed out. The gun liability cases that the NAACP filed against the NRA were dismissed because of intervening congressional action. An unpopular ruling in the Oklahoma bombing case was overruled by congressional action. Terry Schiavo was pending, and we intervened in that case. And the several liability cases have been pointed out that we changed the law with cases that were pending in court. The idea that a dispute should be tried essentially not in a court of law based on the law that applies to everybody, that's fairly applied by an independent judge and jury, but rather in the political branch of government where popularity, not justice, is the key, and political contributions and elections can affect the outcome of a case. Justice in a lawsuit ought to be the same for popular and unpopular litigants. Encouraging what is essentially a trial on the merits in the political branch violates this principle. And so I would hope that we would not encourage people to bring their cases to this branch of government to win on popularity, but to try their cases in the court of law where they're stuck with the same law, independent judge and jury like everybody else. So I would support the amendment.
Maxine Waters.
Thank you very much. Mr. Chairman and members, I was on the floor prepared to take up a bill on flood insurance. And when I heard about this amendment, I rushed down because I thought someone had made a mistake. When they told me it was my friend Mel Watt who was putting forth a strict interpretation of the Constitution relative to retroactivity, I knew they had made a mistake. So I came to make sure that I understood what was happening here, and I do believe that having listened to Mr. Watt somewhat since I came in, and having read the amendment, and then thinking about the way he handles the law, I understand why he did it. I don't agree with it, but I certainly have respect and appreciation for the fact that he believes that the Constitution disfavors retroactivity. And so my staff got together for me a bit of background information. I asked them to get whatever was available on from the Congressional Research Service. And this is what I think basically caps it. In speaking about retroactivity, they say the Constitution disfavors retroactivity, as individuals should have an opportunity to know what the law is and to conform their conduct accordingly. Settled expectations should not lightly be disrupted. Legislators' responsiveness to political pressures, the Supreme Court has said, poses a risk that it may be tempted to use retroactive legislation as a means of retribution against unpopular groups or individuals. And I'm sure that my friend, Attorney Mel Watt, takes this very seriously. Nonetheless, it goes on to say, constitutional restraints on retroactivity are of limited scope and within reasonable bounds. The retroactive application of statutes can be an acceptable or unavoidable means of achieving a legitimate public purpose. As the court has said, retroactivity provisions often serve entirely benign and legitimate purposes, whether to respond to emergencies, to correct mistakes, to prevent circumvention, or a new statute in the interval immediately preceding its passage, or simply to give comprehensive effect to a new law Congress considers salutary. Accordingly, several Supreme Court decisions in the past half-century that address retroactive federal statutes have found them constitutionally inoffensive. So there's no question that the constitutional argument just does not hold water here. I think it has been articulated very well by Mr. Berman and perhaps some others. And in the case of this spill, this historical spill, in the case of everything that we have learned about this spill, and the fact that a claims process was set up very early, and in that claims process, BP said it made a mistake, and it tried to get people to waive their rights in order to receive a claim. In light of the fact that the destruction is so extensive, on and on and on, I think that we certainly should move very aggressively to support this bill and to recognize that we are not in violation of the Constitution in any shape, form, or fashion, but the Supreme Court established this standard in 1984 in Pension Benefits versus R.A. Gray. I will yield back the balance of my time.
Mr. Chairman.
I appreciate that all of my senior members on the committee would like to weigh in on this. The chair is going to ask you to put your comments into the record, and I'm going to call for a vote on the amendment. We're now going to vote on the Watt amendment. All in favor of the Watt amendment indicate by saying aye. All those opposed say no. The Watt amendment is unsuccessful. Mr. Goodlatte.
Chairman, I have an amendment at the desk marked Goodlatte Amendment Number 1.
Clerk will report the amendment.
Goodlatte Amendment Number 1 to H.R. 5503. Strike Section 5.
Gentleman's recognized in support of his amendment.
Well, thank you, Mr. Chairman. Mr. Chairman, as you're aware, several years ago, work that Congressman Rick Boucher and I introduced, the Class Action Fairness Act, was passed through the Congress with overwhelming bipartisan support, passed through the Senate, signed into law by the President, and the provision in H.R. 5503 dealing with class action lawsuits on page 4, section 5, is a very significant loophole that does not just affect maritime incidents, by the way, but would alter the law with regard to all class action lawsuits, and I believe that that section is unnecessary. The supporters of this provision say it's necessary to allow states affected by the oil spill in the Gulf to seek effective legal remedies in their own courts, but the Class Action Fairness Act provision is totally unnecessary because state attorneys general can bring suits as parents patriae on behalf of their citizens without implicating Class Action Fairness Act jurisdiction. Thus, the only real effect of the legislation would be to create a loophole that would keep legitimate class actions out of our federal courts. Here's why Congress should reject this attempt to amend CAFA by deleting the CAFA provision from H.R. 5503. First, some lawsuits brought by state attorneys general are parents patriae cases. That means suits in which the state attorney general seeks to enforce state laws by suing in its sovereign capacity on behalf of the state's citizens and often to seek monetary recoveries from them. These suits are typically brought under state consumer protection statutes. Such suits can only be brought by attorneys general, fall outside of the scope of CAFA because they're not class actions. And we worked very diligently and very carefully, Mr. Boucher and I and a number of others on this committee, to make it very clear that those suits were not covered by CAFA, and therefore attorneys general could bring those suits. CAFA expressly applies to class actions which are defined as any civil action filed in a district court of the United States under Rule 23 of the Federal Rules of Civil Procedure, or any civil action that is removed to a district court of the United States that was originally filed under a state statute or rule of judicial procedure authorizing an action to be brought by one or more representatives as a class action. Unlike class actions, parents patriae cases do not involve any certification process and are not filed by representative class members. Some have claimed that the amendment is necessary because the U.S. Court of Appeals for the Fifth Circuit expanded CAFA jurisdiction to include parents patriae lawsuits in re Katrina Canal litigation breaches. But that case does not support the proposition that all suits initiated by attorneys general may be removed to federal court under CAFA. Rather, the court found that the lawsuit in that case was effectively a class action and not an authentic parents patriae suit because the state joined individual plaintiffs in the action. As a result, the state was not the only real party in interest, which meant that the suit was not an authentic parents patriae action in which the state was suing in its sovereign capacity. As other courts have found in refusing to follow the Katrina ruling, suits brought by state attorneys general are not subject to federal jurisdiction under CAFA when the state is suing in its capacity as a sovereign, and there are a number of cases in which that ruling has been made. Secondly, the CAFA provision of the Spill Act threatens to negate one of the core purposes of the Class Action Fairness Act by creating a loophole that would encourage enterprising attorneys to avoid federal jurisdiction by finding attorneys general to join their class action lawsuits. Rather than promote justice, such a result would promote questionable collaborations between private attorneys and public officials in which the attorneys seek the AG's signature simply in order to avoid federal jurisdiction, and the AGs join essentially private lawsuits for political reasons. Meanwhile, it would do nothing to help the individuals and businesses affected by the Gulf spill. For all these reasons, the CAFA provision in the Spill Act should be deleted from the bill, and I would urge my colleagues to support this amendment and preserve the very carefully balanced legislation that was approved by the Congress and signed into law and has worked very effectively. It does not meet the needs of the Gulf state attorneys general. Their ability to take action under parents patriae lawsuits is preserved and protected in current law.
Mr. Chairman.
Who seeks? Sheila Jackson Lee.
I disagree with my friend, colleague from Virginia, based on the hearing that many seem to want to forget. One representative of the state attorney generals throughout the Gulf who will be filing their lawsuits made it very clear that the present structure of the class action law does not protect, provide the opportunity for lawsuits to be carried forward for the citizens of that state. I think this amendment takes away of the clarification that is in this present legislation. If we recall, BP has consistently said that they will pay every legitimate claim. That raises a question as to their determination of legitimacy. But I can assure them that there will be claims that will be unending. Families who may have initial claims that will generate into secondary claims because of the enormity of this action. Injured workers, states who are now facing enormous environmental concerns, the economy that may be unending. And so states may have a combination of matters that impact the citizens of that state. And the way the present Class Act legislation is drafted, it does not give them the latitude to litigate as they would need to in behalf of the citizens collectively. So I would argue that striking this takes away the clarity that is necessary for incidences like this. And I would hope we don't see another horrific incident like this. But certainly now we have precedent that it can and will occur. If that is the case, I want to make sure that states have the right to be able to represent citizens who are not represented by individual counsel, because the injury is collective. The economy is a collective impact. The idea of the environmental impact is a collective impact. And so I think it is crucial that these states have an unimpeded pathway into the courthouse to be able to recover the enormity of the damages that are impacting them and will impact them, I believe, for decades to come. With that, I just offer my opposition to the amendment and ask for a vote no. I yield back.
Ranking Member Lamar Smith.
Thank you, Mr. Chairman. Mr. Chairman, I support Mr. Goodlatte's amendment, which would remove the Class Action Fairness Act provisions from the underlying bill. The proposed changes to the Class Action Fairness Act and H.R. 5503 are unnecessary and run counter to the very purpose of the Act. The Act was meant to ensure that class actions brought by plaintiffs of one state against the defendants of another state are decided in a neutral, fair forum, the federal courts. History shows that the alternative, permitting such actions in local courts, often leads to unjust results. The Class Action Fairness Act provisions in this bill apply well beyond oil spills. Striking them from this bill will not affect the ability of those harmed by the Gulf oil spill to recover fully for the damages they have suffered. So I support the amendment, and Mr. Chairman, I'll yield the balance of my time to the maker of this amendment, Mr. Goodlatte.
I thank the gentleman for yielding, and I'd like to say in response to the gentleman from Texas that The Attorney General for Mississippi, who raised this issue, cited the very same case that I addressed, the Katrina Canal litigation breaches. And as I pointed out, that was a hybrid case in which the Attorney General of Louisiana had chosen to join a private plaintiff's lawsuit. It did not deprive the ability of the lawsuit to move forward. It simply said, as the Class Action Fairness Act requires, that it could be, on the motion of any of the parties, removed into United States District Court in Louisiana, which in fact is what took place in that case. But the fact of the matter is that the provision in H.R. 5503 would have the effect of removing this from all class action lawsuits for all time and not require the distinction between a parens patriae case brought by a state attorney general on behalf of the citizens of the state, which the Class Action Fairness Act does not apply to in any way, shape, or form, nor would it in any way prohibit a state-contained class action lawsuit from being brought in Mississippi or Louisiana or any state that only involve plaintiffs within that state. That also is not covered by the Class Action Fairness Act. It's only when you have a class action lawsuit that expands beyond the borders of a state and that class action then can be removed to federal district court if it meets certain other criteria. This amendment is totally unnecessary to the purposes sought to be able to preserve the right of state attorneys general and private citizens to bring, in the case of attorneys general parents patriae cases, in the case of private plaintiffs class action lawsuits in the state courts in those states. In the instance where an attorney general chooses to combine with a group of private plaintiffs, there's nothing that the Class Action Fairness Act does to prohibit that lawsuit. It simply says that if it also meets other criteria, then any of the parties to the class action can move to take that case to federal court. This is a good example of why we should not alter major legislation that's been signed into law and has been operating successfully by slipping in a provision into something that is otherwise totally unrelated to it, and this provision in this bill should be taken out.
Thank you very much. Before I recognize my friend Ms. Waters, I'd like to put in the record a letter that came to us Friday to myself and to Lamar Smith as ranking member. And it's a letter from the Attorney General of Mississippi, Jim Hood, who testified on May 27th. And he says, "Dear Chairman Conyers and Ranking Member Smith, please accept this letter as my express support for H.R. 5503. I especially support Sections 4 and 5 of H.R. 5503, the repeal of the Limitation on Liability Act, and the amendment to the Class Action Fairness Act." So I can understand Mr. Goodlett may not have gotten this letter, but you did.
With the chairman.
Yeah, just a minute. I want to tell you what it said. You must hear this before I yield. He goes on to say that British Petroleum and Transocean revealed their legal strategy of attempting to remove all claims, including the state and federal government claims, to federal district court in Houston, Texas. States deserve to have their claims litigated in their courts. Federal law should respect the separate sovereign authority of the states. And that's why I'm putting the letter in to oppose this amendment, Mr. Goodlett, for the simple reason that this is the strategy of keeping litigation going forever, and most states can't afford the expense. So that's why, unfortunately, I can't support your amendment this time, and
Mr.
I will
Chairman,
yield to you.
I thank you for yielding, Mr. Chairman. I'd make the point again that if the Attorney General of Mississippi or Louisiana or any other Gulf state brings a parens patriae case, a case on behalf of all of their citizens in the state courts of the state in which they serve as Attorney General, including Mr. Hood in Mississippi, the Class Action Fairness Act will in no way allow the removal of that case to a federal district court in Houston, Texas, or anywhere else, because those actions are not covered by the Class Action Fairness Act. And if a class action is brought on behalf of the citizens of Mississippi or Louisiana by citizens of that state and not other states as well, then again, it cannot be removed to the federal district courts. Now, once a combined class action is brought involving multiple states, that's the purpose that we have federal district courts for, is to consider disputes involving parties in different states and plaintiffs in different states. And under those circumstances, a case could be removed, but it could not be removed to the location of BP's choice. It would be removed to the federal district court that the laws provide for, and it will most likely not be Houston, Texas. So again, I would reiterate that the multitude of different types of lawsuits brought here will not be covered by the Class Action Fairness Act, and so we shouldn't make a change to the Class Action Fairness Act that's going to affect all class actions in all states that are brought not just.
Do you know this is my time that you're using?
I'll yield back.
Was this? I am stunned because those who support states' rights should rally behind the proposal that states should be able to bring their own claims in their own courts. And I've just read you an excerpt, and again, I should make you a copy of this letter because it's in the record now, in which they've revealed what their strategy is. They testified. It was testified that they go into from Mississippi to Houston, and you're saying that it's okay. They can't afford it. And no, I'm not yielding any more time to you. But the whole idea is that if we were to adopt the Goodlatte Amendment, we'd be sanctioning BP and Transocean's strategy to exhaust the resources of states' attorney generals to bring the claim. And that's why Lamar, he wrote me and you the letter thanking us for Section 5. And now we're up here discussing seriously removing that section. I appeal to a rally for all my states' rights colleagues to join me in defeating this amendment.
Mr. Chairman.
Mr. Coble,
Mr. Chairman.
You're a states' rights man. You're recognized.
Well, thank you. Thank you, Mr. Chairman. I wanted to yield to the gentleman from Virginia, Mr. Goodlatte.
I thank the gentleman for yielding. And, Mr. Chairman, I will say again that while I very much appreciate that the Attorney General of Mississippi has written a letter to you and Mr. Smith, that facts are facts. And the fact is that what he claims in his letter is simply not the case. And the other fact is that this bill, this provision, goes way beyond anything that is related to claims in the Gulf and will apply to all class actions brought under the circumstances provided in that section. If it makes the chairman feel any better, my next amendment is one that limits this to maritime cases in the Gulf related to oil spills. So we certainly do not want to afford BP any advantage, and I think I have made it very plain that the Class Action Fairness Act does not afford BP any advantage whatsoever, and I would urge my colleagues to protect what was passed into law, legislation introduced by myself and Mr. Boucher and supported by many, many Democrats on this committee and in the Congress as a whole. and many Republicans as well. This was very bipartisan legislation. It was worked out in the House and the Senate. It had a very substantial majority in the Senate as well. And this is a very substantial change that goes way beyond helping the plaintiffs in the Gulf.
Mr. Chairman, I'll reclaim and yield back.
Gentlelady from California, Maxine Waters.
Thank you very much, Mr. Chairman. I would like to first compliment you on this legislation, and particularly on Section 5. I remember the debate on the Class Action Fairness Act, and I remember that some of us were concerned about precisely what the Attorney General, Jim Hood, identifies in this letter. In the letter, he says, CAFA has been abused by corporate wrongdoers to improperly delay and remove cases filed by state attorneys general in violation of the 11th Amendment to the United States Constitution, which provides that actions against the state should be decided in state courts. These violations of states' rights cannot stand. I remember that we had this great debate just around the possible abuse of the legislation that finally got passed. Having said that, you pointed out what we learned right here in this committee when we had the hearing where we had the representatives from BP and others when they identified that they had moved to Houston to file in the Houston courts, which I think is very instructive. Having said that, Mr. Chairman, I think that not only should your colleagues on this committee join with you and those who have stood up for states' rights, but I am going to join with Hallie Barbour right now, the governor of Mississippi. Everybody thinks that we are philosophically, diametrically opposed to each other on everything, but today I want the record to reflect that I support Governor Hallie Barbour, and I'm so surprised that we would have members on the opposite side of the aisle who are states' rights opponents and who support the governor who would take this step. After all, even if you're right, wouldn't it be better to err on the side of the victims of this historic oil spill? Wouldn't it be better to make sure that the state's attorney generals have the opportunity to represent the people that have been harmed in their state in the way that this oil spill has done? So I am opposed to this amendment, and I thank you, Mr. Chairman, for making sure that Section 5 is a part of this bill, and I yield back the balance of my time.
Anybody else before? Dan Lundgren.
Thank you very much, Mr. Chairman. Mr. Chairman, I would like to ask my friend from Virginia, as I understand, when you had the Class Action Fairness Act passed, you got a supermajority in the Senate and a supermajority in the House floor
We did
on
indeed.
a bipartisan basis?
We did indeed. And this section of that act was discussed and debated, and amendments were offered as it moved through the process, and we achieved what I think is a very fair balance here with this legislation. But I would say to the gentlewoman from California that I very much respect her concern for plaintiffs. That's what the Class Action Fairness Act is designed to do. It was in response to abuses in which class actions were brought where plaintiffs got, I saw one just the other day, a $3 payment, and the attorneys got $1.3 million in attorney's fees. So we want to make absolutely sure that when actions are brought, they are brought in a fair manner. If a state attorney general chooses to bring an action on behalf of the citizens of that state, the Class Action Fairness Act doesn't even apply at all. So we shouldn't be looking at this. If a private group of plaintiffs bring an action and they bring it within the citizens of that state, they can't remove that case to federal court as well. But it's only when you have multiple plaintiffs in multiple states and multiple defendants that the Class Action Fairness Act applies. And that's why we have federal courts to begin with, to resolve disputes amongst parties from different states. The particular suit that the Attorney General of Mississippi is complaining about deals with a suit that wasn't brought by the Attorney General, it was brought by private plaintiffs, and the Attorney General chose to join in the suit. So it's not a pure parents patriae lawsuit. And that's the only instance in which a suit in which a state attorney general has chosen to join has been allowed to be moved to federal court, and properly so, because it was a private class action lawsuit that fit within the parameters of the law. If the Attorney General of Mississippi brings a suit on his own, he can keep it in the state courts of Mississippi. This provision in this bill is totally unnecessary for this bill, and it is totally detrimental to the legislation that was passed and signed into law with very, very strong bipartisan support, albeit without the support of the gentleman from California.
If I can reclaim my time, is there anything that stops an attorney general from any of the states from bringing a parents patriae action?
Nothing, none whatsoever.
And as I recall, before you had the Class Action Fairness Act passed, we did have instances of where people would get less than $1 as being a member of the class action, but the attorney's fees would be significant, and part of the effort, as I recall, in the Class Action Fairness Act was to try and balance the various interests involved such that individuals who would be members of the class would get a beneficial portion of any return. And it also, did it not require certain types of notices and so forth so that there would be greater transparency?
If the gentleman yield, the gentleman is absolutely correct. The abuse that we had were the so-called coupon settlements, where the settlement would be negotiated between the plaintiff's attorneys, which would be awarded millions of dollars in attorney's fees, the defendant's attorneys, which wanted to get out of the lawsuit, and the plaintiffs got coupons, often to buy more of the product that their attorneys were alleging were defective in the first place. There were major abuses here, and we were careful to make sure that state attorneys general could bring their own lawsuits in their own state and not be affected by that law.
Would the gentleman yield?
I'd be happy to yield.
Well, wait a second, it's my time.
I'd be happy to answer a question if the gentleman from California yields.
I mean, I appreciate the opinion of the gentleman from Mississippi, the Attorney General, but as I recall, during the service when I was Attorney General, we had the largest class action lawsuit with the largest settlement in the history of the world against the tobacco companies. I did not find that the Attorney Generals were somehow forced to the sidelines either at that time or subsequent to the law that you suggest, that you helped pass. And I am at somewhat of a loss to understand the complaint here and the requirement for us in this bill to overturn a piece of legislation that was passed overwhelmingly by the House and the Senate on a bipartisan basis.
Would the gentleman yield?
I'd be happy to yield.
I
don't know. I keep hear a couple net.
Would the gentleman yield? I think I was first.
Oh, I'm sorry. Mr. Johnson was first.
Thank you for yielding to me. I would ask whether or not the Class Action so-called Fairness Act made a distinction between what is a mass action and what is a class action.
I'll be happy to yield to the gentleman from Virginia. He wants to know whether there's a distinction between a class action and a mass action under the terms of the bill that you referred to.
Yeah, there was a distinction drawn between the two.
What is that distinction?
I will be happy to yield to the gentleman from Virginia to be able to respond to the gentleman from Georgia on my time.
That is in the Senate compromise bill that was finally agreed to by the House and passed into law. I can't give you the details right here.
The gentleman yield to me for a second.
Is it not the intent of the manager's amendment to clarify the difference between a mass action and a class action?
No, this is an attempt to clarify.
This is known as a pregnant pause.
To the gentleman from Michigan, I think, on that question.
I would yield to the gentleman from Michigan on that. Well, if I have time to yield.
Let me put it like this. On July 2008, the Fifth Circuit Court in the case of Louisiana versus Allstate found in their decision that the Attorney General actions for a state are subject to the Class Action Fairness Act and can have their cases removed to federal court. That's why Section 5 is in the bill. And taking it out would make this the law of the land, which it currently is. That's what we're trying to change.
If I might reclaim my time, I think I have the time in this roundabout here. I believe that may be true, except if it's a parens patriae case. That is where the Attorney General is acting. The Attorney General is acting on behalf of all of the people of the state he represents and does not have other individual claimants involved, nor has joined together with other attorney generals in their lawsuits.
This was a parent patriae case.
The gentleman yield.
Would the gentleman yield?
If I have time, this is great. I've never had so much time. I'll be happy to yield.
I thank the gentleman for yielding. I think it's very clear from that decision that that was not a parens patriae case. It was a private class action lawsuit which the state attorney general of Louisiana joined as a party. And so a parens patriae case is a case brought by the sovereign on behalf of the citizens of the state, not a suit brought by private plaintiffs that the state attorney general chooses to join. That's a huge difference that is not recognized in your deletion of these provisions in the Class Action Fairness Act that you place in Section 5 of your bill. And that's why that section should be removed from the bill, because it doesn't address the very case that you're talking about there, and is totally unnecessary, but has far-reaching implications well beyond oil spills in the Gulf.
And if I have any time left, Mr.
Can I just claim my own time, Mr. Chairman?
Okay, I'll yield back the balance of my time.
Well, I'll recognize Mr. Watt.
Just long enough to say that I think you're way overstating, the gentleman is way overstating the impact of this, because at worst, this would be a redundancy if what the gentleman is saying. You're making it sound like you're repealing the whole class action statute, and that's not the case. I want to make let me make one other point to make it absolutely clear that there were a number of us who would like to go much further than this language, because we'd like to do away with the whole thing, because we didn't vote for it in the first place. But that's a subject of another day. But I think you're making much more of this language in this bill than the language actually says. At worst, it is a redundancy if your position is correct. And I'll yield to the gentleman if he wants me to yield to him, but that's all I had to say. I'll yield back.
I appreciate the gentleman yielding. The concern here is that plaintiffs' attorneys will bring a private class action lawsuit, and then in order to avoid the purposes of the Class Action Fairness Act, they will get the state attorney general to join with them, and then once that occurs,
reclaiming my time, the gentleman obviously is not reading the language, because it says an action brought by a state or subdivision of a state in both of the sections. And now you're talking about something that's completely different. You're just making up something. You're obviously not reading the language of the bill. It does not go as far as you say. I'd like for it to go as far as you say.
If the gentleman would yield further, if the intention is, as the chairman describes, to overturn the decision in this canal case in Louisiana, that's exactly the circumstance I just described.
Well, you can't look at the intention. You got to look at the language. The language of the bill says what it says. So I don't know what his intention is. I'm just looking at the language of the bill.
Well, I'd ask the chairman what his intention is.
Ladies and gentlemen, before we prepare for the 3 votes on the House, I will call attention to the fact and introduce into the record the Louisiana versus Allstate case, and read you this one sentence. Louisiana asserts that this action is not a class action, but rather a parens patriae action, which the Louisiana Attorney General is statutorily and constitutionally authorized to bring. And in that case, it was held by the Fifth Circuit that the Attorney General's actions are subject to the Class Action Fairness Act and can have their cases removed to the federal court, which is precisely what Section 5 is trying to prohibit. We are now prepared to vote on the Goodlatte Amendment. All in favor indicate by saying aye. All opposed indicate by saying no. A recorded vote is requested. The clerk will call the roll.
Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Berman? Mr. Boucher? Mr. Nadler? Mr. Nadler votes no. Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Ms. Waters? Mr. Delahunt? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Pierre-Louisi? Mr. Pierre-Louisi votes no. Mr. Quigley? Ms. Chu? Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Ms. Baldwin? Ms. Baldwin votes no. Mr. Gonzalez? Mr. Weiner? Mr. Schiff? Mr. Schiff votes no. Ms. Sanchez? Mr. Maffei? Mr. Maffei votes no. Mr. Polis? Mr. Smith? Mr. Smith votes aye. Mr. Goodlatte? Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Gallagly votes aye. Mr. Lundgren? Mr. Lundgren votes aye. Mr. Issa? Mr. Forbes? Mr. Forbes votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes aye. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Rooney? Mr. Rooney votes aye. Mr. Harper? Mr. Harper votes aye. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Cohen votes no.
Clerk will report.
Mr. Chairman, 11 members voted aye, 14 members voted nay.
The amendment is unsuccessful. The committee will, can we record a vote after it's been called?
Men and left, so they would offset each other anyway.
Yeah. We can ask unanimous consent that Mr. Weiner and Mr. Jordan and Ms. Chu be recorded. Okay. Well, somebody go first. I voted in the negative.
Mr. Weiner voted no. Ms. Chu? Ms. Chu votes no. Mr. Jordan is already recorded as voting aye.
Somebody else who came
Mr.
in.
Gallagly came in.
Mr. Gallagly came in.
Mr. Franks?
Mr. Franks is not recorded. Mr. Franks votes aye.
Clerk will report.
Mr. Chairman, 12 members voted aye, 16 members voted nay.
The amendment is not successful. We'll stand in recess till the 3 votes are dispensed with, and then we will resume again. Thank you for your attention.